All right, we're going to go ahead and get started. Welcome to our final day of Boulder County Senior Law Day. I know a day is lasting a month in this world. We are so excited that you're joining us. Before we get started on this program, Estate Planning 101, we have a few announcements. First of all, this is a new virtual format. Sometimes things are a little bit different. Today's webinar is being recorded. The video will be available later on the Boulder County Senior Law Day website. After we're done with these intro slides, I will be posting that link in the chat so you can connect directly to that website. We have muted all participants. Please remain on mute unless someone invites you to unmute yourself. If you have any questions during the presentation, please either put your questions in the chat or the Q&A function at the bottom of your screen. If you are having technical issues, please feel free to put that in the chat as well. And we'll try to troubleshoot as best we can. Our speaker today is asked that you be aware he's going to take questions at the end of his talk because we are a little tight on time today to cover a very big topic. So he will get to as many as he possibly can, but you can feel free to type them into the Q&A as the question occurs to you, and we'll answer them at the end. Today is our last day of Senior Law Day, but there is one more session immediately following this session at 1:15. If you are enjoying learning about Estate Planning 101, the second estate planning talk today is going to be on train wrecks in estate planning. So that should be a fun bonus session that we are adding to celebrate the end of our event. And last second signups can go to bouldercountyseniorlawday.org to sign up for that quickly. I will be posting that link in the chat as well. This year, due to our virtual format, we are not able to offer our usual Ask a Lawyer program. However, our platinum level sponsor, the Boulder County Bar Association, does provide a virtual free legal clinic. Participants are going to be paired up with attorneys and get a brief legal consult. They are covering a lot of different issues, and it's a really wonderful service that they started right after the pandemic hit. To sign up for that, you can call the Bar Association at 303-440-4758, or you can apply online at boulder-bar.org. I will be putting that link in the chat as well. And just checking the chat real quick to see if there is an issue, and for some reason it's not working. So we do have senior law handbooks. Very exciting, always a big draw at our in-person event. There are two ways you can access the handbook. One is online at seniorlawhandbook.org. I will be posting that link in the chat as well. And if you're for some reason unable to access that, please contact Erica Corson at the Boulder County Area Agency on Aging, 303-441-1170 to get a paper copy, or seniorlawhandbook.org to get the digital version. And finally, we want to say thank you to all of our sponsors. We really could not do this event without them. The Bar Association, Pearl Fiduciary, Hofgard Associates, Fraser, Jorgensen, Brownell and Pepin, Assisted Living Locators, Bach Financial, Kingsbury, Johnson and Love, Longmont Senior Services, and Mason Design. And as a special thank you, I do want to thank the rest of the planning committee, who contributed a lot of work. Boulder County Area Agency on Aging's Erica Corson, Pete Rogers, who's a private practice attorney, Margie Greek, my co-chair, who's just been wonderful, and Kurt Hofgard, who is on the phone, about ready to share his presentation and his knowledge. So that being said, I am so excited to introduce Kurt. Kurt Hofgard has been in estate planning in Boulder for over 26 years with his firm Hofgard Associates PC. Kurt enjoys working with clients of all sizes and shapes, regardless of wealth. A Boulder native, Kurt graduated from Stanford and Lewis and Clark Law School, and he didn't brag about this himself, but he is currently our president-elect for the Boulder County Bar Association. He is one of my favorite colleagues to work with. He gives so much of his time to helping the legal community and helping the community understand their legal needs. So Kurt, take it away.
All right. Well, thank you, Brett. And thank you, Senior Law Day, for hosting all of these great seminars for all of us in the Boulder community. Thank you, everyone here, for joining me today. So, Estate Planning 101, we're going to really cover some of the basic concepts in estate planning, and I'll try to finish in enough time to at least answer some of your questions. I encourage people to stick around maybe for the seminar after this too, because they might hit on some of the things that go wrong if you don't do your basic estate plan and some of the more complex things that you might encounter in estate planning. All right, we're really going to cover today some of the basic things that you'll want to think about when you talk to an estate planning attorney, but I really also want to send you away with some things that you can do yourself if you need to. It's some of these things, especially in these times, I've been encouraging people to make sure they take care of things, and in these times of COVID, sometimes people need to do things on a quick basis. So we'll have a few things like that today as well. As Brett said, I've actually been practicing law and estate planning for 26 years. I've focused pretty much exclusively on estate planning, wills, trusts, and unsupervised probate. A little bit about these letters behind my name. JD stands for my law degree, so I am an attorney licensed to practice in Colorado. CLU stands for Chartered Life Underwriter. That means that I have experience in education with life insurance, and we'll talk about this a little bit today, but the way you title your life insurance is an important part of your estate plan. ChFC stands for Chartered Financial Consultant. That means that I have a basic understanding in financial planning, how that relates to estate planning, but I'm not a financial planner. If you want to engage in financial planning or retirement planning, we have really great financial advisors all throughout Boulder Valley here, and CFPs. And in a minute, I'll tell you a way to get in touch with them too. AEP finally stands for Accredited Estate Planner. That means that I have 15 years or more of experience in estate planning. So we're located about a block south of 28th and Arapahoe, broadcasting to you live here from Boulder, Colorado. So with that, let's jump right in. So I often like to point people towards resources that they can go to on their own to get more information on estate planning. So I found a very helpful resource to be the Colorado Bar Association's website. And if you go to the Colorado Bar's website, cobar.org, there's a public interest tab, and you click on that, and then there are some brochures, and many of those brochures are about estate planning. I'll also make a note that this is another way you can look at the Senior Law Day Handbook. I just noticed that recently, that you can actually go on the Colorado Bar's website and get that too. So a lot of ways to get that handbook. So when you go to the Bar's website and look at these brochures, they're about, many of them are about estate planning. So one of the first ones that I point people towards is, what does it mean to be a personal representative in Colorado? So this is the first of several terms we're going to talk about today. Personal representative, that used to be called an executor. A personal representative is somebody who is appointed under a will to transfer the assets according to the will. A personal representative. So every will should have a valid personal representative, a person that you trust to do this, and a backup. There's another brochure that says, what does it mean to be a guardian in Colorado? A guardian is somebody who is actually in charge of the welfare of somebody else. They're in charge of taking care of that person. So anyone who's under 18 generally needs a guardian, or if a person is incapacitated or disabled, then they might also need a guardian. And often a will is one of the first places where people actually name guardians for minor children or grandchildren that they need to. There's another brochure that says, what does it mean to be a trustee in Colorado? A trustee is somebody who manages assets for the benefit of somebody else. So it's a little bit different than the guardian. The guardian is in charge of the person. The trustee is in charge of the assets for the person. And a trustee is named under a trust. A couple of different kinds of trusts we'll talk about in a minute. There's a couple of other ones that are good. There's one that says, what is probate like in Colorado? And as I'll touch upon today, probate in Colorado is actually fairly straightforward and not that expensive. In some states it is, but in my experience, Colorado probate is very, very straightforward. We'll talk about that in a minute. Finally, there's another brochure that says what to do when someone dies, what do you do about contacting Social Security, getting death certificates, some of those things. So very, very helpful brochures on the BAR's website. I also like to point people towards this other website, the Conversation Project. Conversation Project was a movement that was started by the journalist Ellen Goodwin and a few years ago when she needed to really talk to her parents about end-of-life decisions. And now we have chapters all over the country, and we have a really good one in Boulder. And if you go to this website, there's a starter kit where you can start to talk about some of these questions of end-of-life with a loved one or for yourself. So the starter kit is there. I've used it with my family and with clients. It works very well. There's even a COVID-19 resources tab on the Conversation Project. That's very good. All right, so when I've been doing my seminars in the last 3 or 4 months, I like to get right to something that is, I like to get right to some documents that people can actually do themselves if they have to. So in a pinch is where you can find at least 2 out of the 5 documents that I recommend for a basic estate plan. So those 2 are the medical power of attorney and advance directive. A medical power of attorney is where you give somebody the power to make medical decisions for you. And that should be included in any effective estate plan. But you know, I've had plenty of people in the last 6 months who have needed to get this in place quickly before they could meet me over Zoom or talk to me on the phone. And so I pointed them at the Colorado Hospital Association's website, CHA.com. If you click through resources, publications, you go to the bottom of the page of publications, there's a brochure that says your right to make healthcare decisions. You might have seen this brochure when you've gone to your doctor's office or the hospital. And it's a really good brochure explaining your right to make healthcare decisions and what kind of things you might need to put in place. And at the end of that brochure are the 2 forms, the medical power of attorney and the advance directive. And you can actually use those forms in a pinch if you need to. So I've been pointing people towards those. Another form that is important to have in place for some people is called the Medical Orders for Scope of Treatment, also known as MOST. That's a form that's actually signed by your physician. And that is replacing the old CPR or DNR form. That's the one where you can actually state what you want to have happen if you ever got to that point where you decided, yes, I do want, I wouldn't want my heart started back up or breathing started back up. And that's something that you actually can go over with your doctor. But you can go to coloradocareplanning.org, click through that, resources, end-of-life resources, Colorado MOST program, and then it will actually bring up the Colorado MOST form that you can print out, and then you can go over that with your doctor if you need to. Finally, a couple of other resources. If you need to find an estate planning professional, the Boulder County Bar Association's website has Find a Lawyer, and you can actually go under Find a Lawyer to find estate planning, wills, and trusts and probate attorneys. Good listing of all our fine attorneys here in Boulder County that can help you with your estate plan. Another place to go is the Boulder County Estate Planning Council's website, boulderestateplan.org. You can go to the directory there, and not only can you find some attorneys there, but you can find certified financial planners, CPAs, insurance professionals. This is a group, an organization where we get together every month or 2 and talk about topics of estate planning, and these are professionals that deal with estate planning. So if you need one of these professionals as part of your team, I encourage you to go there as well. All right, let's jump right into Estate Planning 101 with some quotes about estate planning. There's a probate judge who said, "We see a lot of sad things here. It's heartbreaking when you go into court and you know what the person wanted and he just didn't get around to doing it." This is really about building an estate. No generation can bequeath to its successor what it has not got. I like this one. Someone sitting in the shade today because someone planted a tree a long time ago. You never know how many generations or people you can positively affect with an effective estate plan. I like this one too. It's kind of funny. Death is not the end. There remains the litigation over the estate. Well, that's actually what we're trying to avoid. You'll hear about litigation over the estate in the next presentation, but with an effective estate plan, this is what you are trying to avoid. You're trying to avoid that your estate going into court or for there to be conflict in your family. A goal without a plan is just a wish. This might motivate some of you to get going on your estate planning. This is kind of an interesting quote. He was a very smart man, but he died like an idiot. Okay, so this is a friend of a New York man who died in 2012, a $40 million estate, but no will, no identifiable surviving heirs, leaving most of the estate to possibly go to the state of New York. So here's an interesting legal term, escheat. Escheat, that means that a person did not have an estate plan at all, and they had no surviving heirs. So it used to be the king who would get this, and now for all of us, it's the state of Colorado. For this gentleman, it's the state of New York. Kind of an interesting story. He was a Holocaust survivor. He came here after the war, and he got married, built up a successful real estate business, but he and his wife never had kids. His wife predeceased him. And he was actually very connected in his community. He had a lot of things, a lot of people and causes, a lot of people he was friends with, a lot of causes that he gave to. His friends kept saying, you got to get your estate plan done. Well, he said, yeah, I'll get around to it, but he never did. So here we are now, and the estate has been whittled down to maybe 25 million because of all the costs. Some people have come forward and said that they are heirs of him, that they can't really find anybody who's related to him. So it's possible this might actually escheat to the state of New York. That's definitely not an effective estate plan. And, oops, sorry, skipped through a little bit. The only way you can beat the lawyers is to die with nothing. That's a good estate plan, right? There's not an effective estate plan. Someone who was about to get aboard the Titanic. I swear that as soon as we get into port, I'll see about getting that will made. That's not effective. So I like this quote. There's a false mystique to asset protection planning that has often allowed planners to charge premium prices for selling cutting-edge strategies to their clients when boring and inexpensive solutions would work better. This really gets to our firm's approach in estate planning. We want our clients to have estate plans that work for them, not necessarily ones that are overly complex or more than what they need. Use LegalZoom to create your own will. Tell them again about your years of legal experience. So I like to take a little dig at LegalZoom here, and there have been problems with LegalZoom. There was a class action lawsuit a few years back in California with a lot of wills that didn't do what they were supposed to. So you have to watch out if you use LegalZoom. Now that said, using LegalZoom is better than doing nothing at all. Okay, so I would never encourage anyone to do nothing as far as estate plan. It's better to do something yourself than do nothing at all. In fact, I want to send you home with 3 things you can do yourself. You can actually create your own will in a pinch if you need to. There are really 2 ways of doing this. The first one is to use a program like LegalZoom. I don't necessarily endorse LegalZoom over any other one, so I call the ones online LegalZoom wills. So if you decide to do a LegalZoom will, there are 2 things to remember. One is you can't just print out the will at the end and sign it and stick it in your desk drawer. That is not a valid will. For a will that's printed out, either a notary or 2 witnesses have to watch you sign it. That's the Colorado rule. Before the COVID struck here, we usually in our office had 2 witnesses and a notary watch you sign it. Since then, we've actually gone to remote notarization, and a remotely notarized will in Colorado is valid because of some of the statute that was passed at the end of June. So it actually can be done with just a notary, and it can be done remotely right now. That's actually what we're doing in our practice because we want to keep everyone safe, and we're still thinking it's not quite time to open up yet. That's for sure. So notary or 2 witnesses have to watch you sign it if you do a LegalZoom type will. Second thing to remember with the LegalZoom will is that you want to make sure that you go through every screen. How many people out there do your own taxes? So I like to do my own taxes. I use TurboTax, and what I've learned over the years is that you really want to follow every screen and fill in all the information, or you might end up with a tax return that's not effective. It either understates your income so that IRS might come after you, or you might do something else where you actually are giving, you're not getting deductions that you're supposed to. It's the same thing with the LegalZoom will. You don't want a will in the end that's missing information. I've seen LegalZoom wills, for example. I saw one where it had the heirs in the will, but it didn't have the person in charge, the personal representative. And I saw another one where it was probably even worse. It had the personal representative, but it didn't say who the estate went to. So make sure you go through LegalZoom carefully if you decide to do that. The second way to do your own will, if you really need to, is called a holographic will. A holographic will. That means that the whole will is written out. It's all in your own handwriting. You don't type it out or sign it. All in your own handwriting. If you do that, and I've had people do that in a pinch, then two things to remember. One, you have to handwrite the whole thing out, okay, and sign it. Then it does not need to be witnessed or notarized. Two, someone other than you needs to be able to find that, okay? So you can't just squirrel it away and hope somebody will find it. Make sure you let somebody know where that is, so in case it comes about, that it's actually effective. Now, do I think that actually using LegalZoom or holographic will is as good as going to an estate planning professional? Well, I'm biased, but I think I can probably spot issues that you might not have when you did your own will. So I encourage everyone to go to an estate planning professional, even for these basic documents, really to make sure everything is covered. All right, moving on to estate planning 101. Let's talk about we're going to get to what is effective estate planning. But first, let's answer the question, what is not estate planning? The answer is there's nothing that is not estate planning. All of us right now on this presentation have an estate plan, whether you've done something or not. Why is that? It's because of the two basic facts of life. Benjamin Franklin gave these facts of life: death and taxes. The first fact of life goes like this: death, 1 out of 1. That's how many people die. All right, second fact of life is similar to taxes, is the fact that everyone has an estate. You might think that an estate is only within the purview of the very wealthy, but no, your property that you own, the clothes on your back, your car, your home, your checking account, savings account, your retirement plan, these are all assets. These are all types of property that are in your estate. So because everyone has an estate and everyone eventually dies, the question becomes, who has the right to the property of a person who has died? Now, you can take advantage of one of the 4 methods we're going to talk about in a minute. Or if you haven't, there's a set of laws that dictates who has the right to your property if you die. If someone dies without an estate plan, they've died intestate. So intestate is when somebody's died without an estate plan. And there's a whole set of laws of intestacy. Every state has a set of laws. Colorado's set of laws goes like this. If you die without any kind of estate plan, who has the right to your estate? Well, if you're married, it's usually your spouse. If you're not married but you have kids, then it's your kids. If you're not married, you don't have kids, it's usually your parents, and out the family tree like that. So even if you've done nothing, there is an estate plan in place, the laws of intestacy. Now, is that the way you necessarily want it to go? Maybe not. So why don't you take advantage of your opportunity to estate plan? That's what I would say. So really the question then is, what is effective estate planning? And to get into this, now we're going to talk about what is in your estate, different kinds of property. So this is really the process that we go through with our clients and prospective clients. And, since they're recording the session today and you can look back at my PowerPoint presentation, you could use this as a guide to actually take inventory of what your estate is. So the questions we're going to ask: what is in your estate? How is it owned right now? How much is it worth right now? And how is it designated to pass right now? First kind of property most people think about is real estate. So that includes the primary residence, rental property or vacation property. Here's some of the questions we'll ask. Does it have a mortgage? What's its fair market value? Where is the real estate located? Colorado or another state or country? Now, you might have heard of an estate planning technique called a revocable living trust. Well, in my opinion, a revocable living trust is very useful if you have property outside of Colorado. And in that state where you have property, if the probate process is very expensive and burdensome in that state. For example, California. California is known to have an expensive, time-consuming, burdensome probate process. Colorado, on the other hand, does not have an expensive, burdensome process. But what if you are a Colorado resident, but you own property in this other state? Well, here's a basic rule. Real estate goes through probate in the state where it's located. Everything else depends on where you are a resident when you die. So let's use an example. Let's say I'm a Colorado resident, but I own a condo in Lake Tahoe, California. So if I die owning that condo, there will be a Colorado probate process for almost everything except for that condo, and then there will be a California probate process for that condo. Well, we want to avoid that California probate process. So what do? Well, I can set up a trust called a revocable living trust, meaning I can change it as long as I'm alive. I can get rid of it. I can put property in and out of it. It's an arrangement that I set up. And as long as I'm around, I can be the trustee and the beneficiary as well. But the key is, what I'll do is I'll actually transfer my California property into that trust. I'll actually will file a deed in California that will transfer my property in that trust, and that will avoid the California probate process. Why is that? Well, if I die, I'm subject to Colorado probate, but the entity that owns the California property keeps going. The successor trustee, per the arrangement in the trust, steps up and will distribute that trust the way I want, and voila, we've avoided California probate. So revocable living trust, good way to actually avoid probate where probate's burdensome. Next question on real estate, do you own it with someone else? Who do you own it with and how? There are a couple of ways of owning real estate that we'll talk about in a minute too. Is it part of a business, part of an LLC or corporation? If that's the case, there are some special considerations. All right, next asset most people think about are their retirement plans. That includes IRAs, 401ks, simple SEPs, 403bs, 457 plans. Maybe you're fortunate enough to have a defined benefit plan, a pension. If you do, hang on to that. So here's the question we're going to ask on retirement plans. Who are the primary and secondary beneficiaries? So the primary beneficiary, the person who would get it if you were to die. Secondary is if you outlive the primary beneficiary. So we talked about the fact that you can do your own will. Well, here's the second do-it-yourself thing you can do. You can check your beneficiary designations on your retirement plans. That's something that you can do on your own as well without going to any kind of estate planning professionals. You can either do this by going online, or if you have an investment advisor, you can just ask them. And here's the great thing about retirement plans and 401ks and IRAs and so forth. That asset will go directly to that beneficiary outside of any wills or trusts or anything like that. So great way to do some basic planning, and very easy to check that as well. Same thing with life insurance and annuities. That also passes by beneficiary designation. So that's a great way to create an instant estate. You know, if you want to send somebody $100,000 at death, life insurance, that's a great way to do that. Primary, secondary beneficiaries, you'll want to check on that as well. Maybe you have business interests, either as a sole proprietor or a corporation. Maybe you have LLC and partnership interests as well. These are also assets that are part of your estate. If you're in partnership with someone else in business, you want to make sure you have what's called a buy-sell agreement. So if one partner dies, the surviving partner can continue business, but the family of the deceased partner will sell it to the surviving partners. Family gets some value from the business. Surviving partner keeps going into business without somebody else interfering in the business. Buy-sell agreement. And of course, if you have business interests, make sure you have the right kind of insurance in place as well, liability protection. Other intangible personal property. These are also assets that are in your estate. So that includes after-tax investment portfolios, mutual funds, stocks, bonds, money market, your checking, your savings accounts, your CDs. These are also assets that are part of your estate. Maybe you have a college savings plan. That's also part of your estate, like a 529 plan. Finally, tangible personal property. Whoops. That could be like vehicles, jewelry, family heirlooms, artwork, collectibles, musical instruments, pets. Pets are considered tangible personal property. So if you have certain people that you want to get tangible personal property, make sure that you do something called a personal property memo. That's similar to a holographic will. It's something that you can actually do in your own handwriting and sign, and it doesn't have to be witnessed or notarized. So we usually recommend doing this outside of the will, because every time you change who you want to get this or that item, you don't want to have to change your will and go through all the hoops of getting the will signed. If it can be done with personal property memo, that's a lot easier. So in the wills that we draft, that's usually called out at the beginning. It says, if I've done a personal property memo, go ahead and distribute these items out first, then we'll get to the big things in the estate. All right, so now once you've taken inventory of your estate, now we're going to add up everything and see if your estate is taxable or not. So you look at the net amount, so minus out any debt. Remember to include death benefit of any life insurance. The question is the estate taxable or not? Well, for most of my clients, most people I'm talking to these days, they don't have to worry about the federal estate tax. Okay, that's probably good news. A lot of people didn't know that, but right now it's 11.58 million for a single person or 23.16 million for a married couple. If you're below that amount, you don't have to worry about the federal estate tax, and there's no Colorado estate tax. Now, here's this is kind of for reference. This is how the estate tax exemption has gone up since I started. Look, in 1997, it was at 600,000 for a person. So everything above that was estate taxable. Then it went up to 3.5 million. Then it was gone for 1 year. Then it went to 5 million. Then in 2018, it was doubled. Now, if Congress and the president, whoever they are at the time in 2026, if they don't do anything, then the law that was passed in 2017 will sunset, and it will go back to 5 million per person, 10 million for a married couple. So if you're in that range, then you might want to think about some techniques for reducing the estate tax. Otherwise, estate tax usually isn't a big concern for most people. All right, so now you've taken inventory of your estate, figured out what's in it. We thought a little bit about taxes. Let's stop and step back and ask, who are you really planning for? Are you married, single, domestic partners, widowed, divorced, remarried? Do you have children or not? If you have children, are they minors, meaning under the age of 18? Or what they are, are your children what I call young adult children, anywhere from 18 to 60. So young adult children is technically an adult over the age of 18, but for whatever reason, it would be a bad idea to have that person get a lot of money at once, for whatever reason. Now, if you are planning and you have young adult children, then we'll usually recommend not just a basic will, but a will with a testamentary trust. Will with a testamentary trust. So that is a little trust that's part of the will. So it's different than that revocable living trust we talked about a minute ago. The purpose of the testamentary trust, the little trust under the will, is to make sure if the parent or both parents pass away, then the assets are managed for the young adult children instead of them getting all the assets at age 18. And so that's where you'll actually name a trustee under your will, and you can actually say the ages at which the children have a right to the assets. As, typical one we use in our will is they have a right to a third at 25, half at age 30, and the rest at 35. But that's up to you. Some people think that's too long, and they should have a right at 21 and 25. Some people like it to be longer, 40, 50. That's totally up to you. Or now you have children from previous marriages, what I call a Brady Bunch family. In that case, if he wants his assets to go to his kids and she wants hers to go to her kids, then there's some special considerations as well we have to take into account. Do you have grandchildren you want to plan for? Finally, do you have charitable intent? Do you want assets to go to nonprofits? If you do want assets to go to nonprofits, you definitely have to take advantage of one of these methods of estate plan we're going to talk about now. Because remember, if you have done nothing at all, then the laws of intestacy will take care of everything. And they will go to a relative of yours. And if there are no relatives on the face of the earth that can be found, then it would escheat to the state of Colorado. That's pretty rare, but definitely if you have charitable intent, then you want to go ahead and include that in your estate plan and engage in effective estate planning. Effective estate planning, we've been talking about death, but it's also planning for possible incapacity or disability. So we won't just want to draft a will or trust for you. You also want to have in place the powers of attorney, financial power of attorney, and healthcare power of attorney, and some of those documents we'll talk about in a minute. All right, 4 ways that you can estate plan. All right, the first one is what's called by operation of law. And really what this means is do you own property in joint tenancy with someone else or not? So let's talk about this. And this usually deals with real estate. And so either spouses or business partners or friends, they own real estate together. And there are 2 ways of owning real estate together. The first is called joint tenancy. The second is called tenants in common. What's the difference between these 2? Well, when 2 people own property in joint tenancy, if one of the joint tenants dies, the surviving joint tenant automatically inherits that property. It's outside of any will or probate. So easy way to do some basic planning is to have property in joint tenancy. Well, what does tenants in common mean? Well, 2 people own property as tenants in common. One of the tenants in common dies. That person's half does not automatically go to the surviving tenant in common. It will go according to his or her will or trust. So that's the difference. Now here's the third do-it-yourself thing you can do. you can actually check the deed on your property if you own it with someone else and see if it's in joint tenancy or not. So you actually look at the deed from when you bought the property. So you actually weren't the one that signed it. The people that sold you your house signed the property, but you're listed as the buyers or purchasers. And after your names will be the words as joint tenants, or as joint tenants with right of survivorship, or some variation thereof with joint tenants, or not. So the Colorado rule is those words as joint tenants or joint tenants right of survivorship, those have to be on the deed for the property to be in joint tenancy. If those words are not on the deed, then it passes by tenants in common. So how do you check this? Well, you can actually look at the deed from when you bought the property, or you can actually go on the Boulder County Clerk and Recorder's website, navigate through that a little bit, and for $2.50, you can actually download a copy of the deed for your property. You can actually see if it's in joint tenancy or not. If it's not, it's very easy to correct. You can file a new deed that puts your property into joint tenancy. So for a married couple especially, I almost always recommend that the property be in joint tenancy so that you don't have to worry about wills or probate or anything like that. And the reason it's important to check this is sometimes in the rush to close things, the real estate professionals sometimes don't catch this. I've seen this a couple times, so that a married couple has the property, but the words joint tenants are not on the deed. And then if one of the spouses dies, the survivor actually has to open up probate according to a will or laws of intestacy to move the property to himself or herself. So definitely important to take care of that. Finally, I always like to mention there's another way to transfer property that's pretty straightforward called a beneficiary deed. Beneficiary deeds is like joint tenancy, where you can actually file a deed with the county clerk and recorder where you state, here's who I want to get my real property when I die. And it operates just like joint tenancy. The beneficiaries listed on that deed will actually get that property outside of wills or probate. So I usually recommend this for people who are at close to the end of life than the beginning, and that they really know who they want to get the asset. For example, I had a single client with real estate who had just one adult daughter, and beneficiary deed worked pretty well for him because he knew that he wanted her to have all that property. For somebody who has multiple beneficiaries, or you might change your mind, beneficiary deed might not be the best way to do things, because if you want to change the beneficiary deed, you actually have to file a new beneficiary deed with the county clerk and recorder. Whereas if you change things through a will, the will is not actually filed with any governmental authority. All right, the second way to engage in effective estate planning, so we talked about by operation of law, that means joint tenancy. Second way is called by contract. And really what we're talking about here is the beneficiary designation, a great way to pass assets very quickly and easily to your heirs. This includes retirement plans, life insurance, annuities. A lot of times you can do a payable on death or a transfer on death designation on a checking account or savings account as well. So these are all types of beneficiary designations. Great way to do basic planning. But I want to make one important point to everyone here. The beneficiary designation supersedes what's in any will or trust. I'll say that again, beneficiary designation supersedes what's in any will or trust. So if you think you want to send your assets through your will, and you're thinking, oh, I want my life insurance policy to go according to my will, you'll want to go back and check your beneficiary designation on your life insurance, because whatever you put there, whether it's after you made the will or before, that will supersede the will. So very important to get that beneficiary designation right. All right, third way that property is transferred. Now we're going to talk a little bit about probate. So if it's not by joint tenancy and it's not by a beneficiary designation, then generally it will be according to probate. And when we have probate, you either have a proceeding where the person had a will or they did not. So testate is when they had a will, intestate is without. Most probate proceedings in Boulder County and Colorado are unsupervised and informal. So a very, very easy, straightforward process. There are supervised formal processes for when you have something like a will contest or irregularities with the will. And that's usually when you get into probate litigation. And I would imagine that my colleagues will be talking about that in the presentation after this. I personally don't like to go to court, and I don't like to litigate. I like to help people plan and avoid litigation, but sometimes it's necessary. And we have some excellent probate litigation attorneys here in Boulder County as well, if you ever need that. So when I'm talking about probate, I also like to mention something called the spousal elective share. There's one person you cannot disinherit. That's your spouse. So, the rule, Colorado rule, is 5% per year up to 50% or 10 years of marriage. So give an example of that. Let's say two people were married for 5 years, husband and wife, and husband in his will gave everything to his best friend. Well, the wife, after the husband dies, could contest that will, and she could say, I'm going to elect against the will. What does she have a right to? She has a right to 5% times 5 years, 25% of the husband's estate. So sometimes people ask, how do we get around that? If we have a second marriage where he wants his to go to his kids and she wants hers to go to her kids, well, that can be done through a prenuptial or postnuptial agreement where both spouses waive the right to spousal elective share by contract. And that way, that ensures that her will says she gets her kids get her assets, goes that way, his go to his kids. That's how you actually get around the spousal elective share. All right, a little bit about probate. I like to say Colorado probate is 5 days, generally 10 steps in 6 months. And again, some people say, why do we have to have probate? Probate's kind of it's considered a dirty word for people. It's actually not that big a deal, in my opinion. But the reason for probate is if someone doesn't have an estate plan or their assets don't pass by beneficiary designation or joint tenancy, then again, everyone dies and everyone has an estate. We have to figure out who has the right to that property. So that's the reason for probate. 5 days. So somebody dies, you have to wait at least 5 days, but as soon as 5 days have passed, the personal representative, also known as the executor, named in the will, can submit the will to the probate clerk in the county where the person died. Probate estate has to remain open for 6 months in Colorado. Here are the 10 basic steps, which I'll go through kind of quickly here. Personal representative gets appointed. So sends the original will and some paperwork to the probate registrar or clerk in the county where the person died. So don't actually have to go to court or go before a judge or anything like that. I've seen people actually do this themselves. It can be a little bit burdensome and time consuming for someone that's never done it. But I've seen people do it themselves. Submit the paperwork. If everything's in order, if it's the original will, the probate clerk will send what are called letters of administration back to the personal representative. That's the magic piece of paper that gives the personal representative authority to deal with the estate. So here's some of the other things that the personal representative will do. They might need to honor the last wishes of the deceased, burial or cremation, and so forth. If the will lists who are supposed to be guardians for minors, then the personal representative will help get the guardian appointed. Next, marshal the assets. This is why it's so important to go through the process we did earlier, which is to take inventory of what's in your estate and have that at least somewhere in your house with your estate plan and update it periodically so that your heirs actually know what you own. You're usually not listing the assets right in the will or trust. Maintain the estate. Keep the electricity going, pay the mortgage. Deal with any creditors of the estate. Make sure that legitimate creditors are actually paid. As soon as the personal representative is appointed, that person can actually list the real estate and sell the property. There's no waiting period like there is in some other states. Pretty straightforward in Colorado. Pay taxes and prepare any accountings. Distribute the property to individuals or trusts, and finally close the estate. It has to remain open for 6 months, but there's no reason why it can't remain open longer than 6 months. And here's something a lot of people don't know. As soon as the personal representative is appointed, they do have the authority to make distributions to the heirs. There's no waiting period on that for Colorado either. All right, last method of estate planning is by trust. So we've talked about two different kinds of trust. You have a revocable living trust. The purpose of that is usually to avoid probate where it's expensive or time consuming. And you have testamentary trust, which is a little trust that's under a will. Will and trust are all one document. The purpose of that is to transfer assets to minor or young adult or incapacitated beneficiaries and make sure it's managed for them. All right, the ultimate two questions we're really asking in estate planning. Ask yourself, who do I want to be in charge of things? That's called a personal representative or executor. Where do the assets go? Individuals, trusts, or nonprofits? And here are the 5 documents everyone should have. Everyone should have a will. And if you have minor or young adult children, you want to have a will with a testamentary trust. And minor or young adult children, you'll name the guardian and the trustee and You'll also, in any kind of will, name a personal representative and where the assets go, trust individuals or nonprofits. Everyone should have a financial power of attorney. That's where you name an agent who can make financial decisions for you if you're incapacitated, pay your bills, and make sure investment decisions are made for you. And you always want to have backups in all of these as well, in case the first person can or doesn't want to take the job on. Healthcare power of attorney. Everyone should have this. And we referenced earlier, CHA, Colorado Hospital Association, has that form if you need to do it in a pinch. So a healthcare power of attorney, where you name somebody to make healthcare decisions for you. Everyone should have a HIPAA authorization, so that you're saying to doctors and hospitals, it's okay to release my information to my agents. Finally, everyone should have an advance directive, a living will. That's the document where you state in the very end, if the only thing I'm on is life-sustaining procedures and or artificial nourishment, and 2 doctors have said in writing, there's no way I'm coming back and I'm not communicating at all. What do I want done? Do I want that withdrawn or kept going for a number of days or kept going? So in addition to the 5 documents, take advantage, well, and also you might need a most form. Take advantage of the other methods of estate planning we talked about. Make sure real estate held with somebody else is in joint tenancy if you want that. Make sure your beneficiary designations are updated and in place for life insurance, IRAs, and so forth, retirement plans, and POD. All right, so we covered a lot of ground with basic estate planning. I'm sure we have a lot of questions. So why don't we go ahead and stop the share, and I will go to either the, I think I'll go to the Q&A first. All right, first question, do do-it-yourself forms need to be notarized? Well, if it's actually a printed will, yes, that does need to be notarized. If you have done a holographic will in your own handwriting, that does not need to be witnessed or notarized, but anything that is printed up either needs to have a notary or 2 witnesses watch you sign it, and that's in terms of wills. With the other forms, it varies. Some of them, like the advance directive, that needs witnesses, and the other forms usually need notary. How about foster adopted children? Is it still the same process? Yes, because usually in your will, you will define who your children are. And of course, in beneficiary designation, you can name anyone, whether it's a natural child, adopted child, or foster child. So generally, yes, it is the same process. But that said, it's important to be very clear in your will who your children are, and if you're going to consider adopted or foster children your children. So important to define that. Are there professionals that you can ask to be your medical power of attorney? I'm reluctant to put that pressure on friends, and I don't have a connection with my family. There actually are some people and some organizations. There are organizations that you can ask to be medical power of attorney. You know, certainly if you would like to talk about that, make sure you email me or contact me, and I can put you in touch with some of those people. The chat has the next group of questions, so I'm going to go right to that. All right. Anything's better than being intestate. That's the first comment. That is very true. So even, I always encourage everyone, you know, even if you do it yourself, either through LegalZoom or holographic, well, that's better than doing nothing at all. Thank you. Okay, so I don't know if I'm getting more questions on the chat.
There's one down at the bottom. We moved here from Virginia 4 years ago. We have a Virginia will. How soon should we get a Colorado will?
Oh, right. That's an excellent question. So in my experience, the different states do respect each other's wills. So I've probated wills from other states plenty of times. So as long as it's either has 2 witnesses watch you sign it and or a notary, then that will be valid in Colorado. Now that said, I do recommend that when someone moves to a new state, they do talk to an estate planner in that state. And I recommend this for people to move outside of Colorado too, because each state has a little bit different on it approaches this a little bit differently. But that said, if you do have a valid will and it's the original will, then if you need to wait a little bit, I think that's okay. How often do you recommend your clients review their revocable living trust? Yeah, I would say for all your estate planning documents, probably you should review them at least every 2 to 3 years to see mostly if the people that you've named in there are still the people that you want to be backup trustee, personal representative of all of those things. And I do definitely recommend that most documents, at least the power of attorney forms, after 10 years, it's probably a good idea to redo those. I mean, they still might be honored by a bank or hospital, but when they start to get too old, I worry about a bank or hospital not honoring a document that's too old. Can you, can you elaborate on the boring but less cost-effective options? Yes. So, in my experience, I have seen sometimes clients who have done estate planning before, and it's been a bit of overkill. Maybe that client really needed just a basic will, and they didn't have out-of-state Colorado real estate, and they didn't have a very large estate that would pass by their will, maybe just their real estate. In that case, maybe a will planning would have been just fine, and they didn't need to go to the extent of doing a revocable living trust. That'd be an example of that. Let's see, I own property through Boulder Affordable Program. Do I have to work with them on the deed to my home, or can I leave it to whoever I want? So, you know, my experience with Boulder Affordable is to check with them, make sure that you wouldn't be running into any problems if you left it to somebody. From what I've seen so far, they've said, well, that's a property interest that you have, and you're free to leave that to whoever you want. But I would definitely talk to them and check with them. Oh, okay. Well, I thought I'd have some more questions. That's why I talk so fast. But I'll wait here a minute and see if we have any more. Well, if we don't, I could.
And we did have one pop up just now.
How about mobile home? Mobile homes, that's interesting. Mobile homes are actually, my understanding is that the mobile home itself is personal property, and it's that's not real estate. So definitely, you know, but sometimes the lot under it goes along with the mobile home, and that is real estate. So, you know, it depends on the situation, but definitely a mobile home would be covered by your will, unless you have it in joint tenancy with somebody else. So, you know, that's another asset that's part of your estate that you want to make sure you take care of. What's my email address? It is hofgardlaw, HOFGARD law @gmail.com. Okay. Oh, wow. Now we're getting a lot of questions. Okay. Who should have a copy of your will? So I think it's important for your first backup personal representative or trustee to either have a copy of your will or to be able to access your will very quickly. So the first person that you've named in your will as the backup, as your first backup personal representative, that should be the person that should either have a copy of it or know how to get it. I consider some people in my family who are not legal or blood relatives. Are there problems with leaving assets to them? No, there's no problem with leaving your assets to whomever you want. So remember, the only person you really cannot disinherit is your spouse. But if you do have people who are not your relatives, definitely you need to take advantage of one of these methods of estate planning. You know, make sure you have a valid will that has them in there, name them beneficiary on assets if you want. But it's not a problem leaving assets to them as long as you have a plan in place to do so. Let's see. Other than the court and the appointed executor on the will, can it be kept confidential? Yes. Well, technically, here's what it comes down to. A will, when it is probate, is technically considered public record. Now, public record doesn't mean like it's printed in the newspaper. That just means somebody can view it if they decide that they want to look at the wills. I don't really know of anyone who does that anymore. But what is the best way to keep everything confidential? Well, that might be the use of a revocable living trust, where you actually have a separate entity that's not subject to probate at all, actually hold your assets. So that would be a reason possibly to do a revocable living trust. Is a common law spouse a spouse? My understanding, and Brett knows a little bit about this, but common law is recognized in Colorado. So if a person, now there's some criteria for being a common law spouse. Do you file your taxes together? Do you hold yourselves out as husband and wife? And are you listed together as husband and wife on documents? But yes, a common law spouse is considered a spouse in Colorado. Do I have to have the original copy of your will for my late husband to close it out? Yes, generally to probate the will, you do have to have the original. If you don't, there are ways to actually probate the copy. I've learned this over time too. You can actually, if the will has been lost, there are ways to do that as well. Can you comment on concerns regarding charities who suggest you leave a large amount to them now and get an annuity from them over time? Well, I would have to say that's a financial planning question. So I've seen people do this if that's what you want to do. There are techniques for doing this. If you have charitable intent, there's one called a charitable remainder trust. There's a very easy one called a gift annuity. And I think those actually do work very well. But I do definitely recommend, if you are going to think about doing something like that, to talk to a financial planner in tandem with talking to the charity.
Great. So I think we just hit our time here. I'm going to share my screen just to show our sponsors again, because we are just so very, very grateful to them. And thank you to everyone who came and listened to us. And yeah, if you're sticking around for the bonus session, we'll log off and log back on in 15 minutes. And again, this will be posted on our YouTube channel.
All right. Thank you, everyone. Thank you for coming today.
Great. Thank you.